So leading straight into our very next panel, it's going to be a legislative debrief. As you've probably noticed, we've tried to pair this morning very carefully two very important branches in terms of how it is that groundwater policy is made through legislation and then also with case law. And because we've just concluded an important groundwater session, we thought we would bring up a panel of experts to discuss some of that legislation, the impact on GCDs. So I'd like to start by asking each of you to briefly introduce yourself, who you work with, and what your role has been in this process.
Yes, Ty Embrey. I'm a principal at Lloyd Gosselink law firm in Austin and represent numerous water interests, including multiple groundwater districts. So, and have spent time at the Capitol representing those water interests, plus worked at the Capitol for the Senate Natural Resources Committee before I went to private practice at Lloyd Gosselink.
Hi, my name is Hope Wells, and I'm an attorney with the San Antonio Water System. I work on state legislative and regulatory affairs quite a bit for the system. Before that, I worked for the legislature for a number of years in the House Natural Resources Committee as well, so I've kind of done both sides, as well as I co-chair a groundwater committee through the Texas Water Conservation Association with Brian Sledge here, which we'll talk about more as we go.
Thank you.
I'm Greg Ellis. I have been working in water and groundwater issues for the better part of 30 years now. I have a solo practice. I only represent groundwater conservation districts, with the only exception being, I think, the Texas Water Foundation, where I serve as secretary of their board and as their general counsel. That makes it easy to just be on one side of the issue, although there are occasionally conflicts between my clients. It's been a real pleasure working with the groundwater conservation districts and helping to work on Chapter 36 in the legislature and work on the rules after the legislature's finished making their changes.
Thank you very much.
I'm Brian Sledge. I'm an avid hunter and fisherman and extreme sports enthusiast, and I dabble in a little bit of law on the side. No, I'm an attorney with the SledgeLaw group in Austin, and also have an active practice in the Capitol. Do mostly water and environmental law, other local governmental law matters. Like Hope, I was at the legislature to start off after law school with the House Natural Resources Committee. I served a brief stint as Director of Research for the Texas Water Development Board before entering private practice. And along with Hope and these other folks and a whole lot of other folks in the room, I spent a whole lot of time working on the consensus groundwater process through TWCA and TAG.
Perfect, thank you. So as we heard briefly from Chairman Perry this morning, I wanted to start this conversation by asking you perhaps to characterize what you thought overall the 85th legislature was like. What are the themes that dominated the discussion? Could you kind of give us a description of the playing field? Ty, I'll turn to you.
Okay. I think Chairman Perry used the term hard. It was a hard session, and I think that was across the board. I think everybody felt that way. I've been working up at the Capitol in some capacity for 20 plus years. I've never seen the leadership, Lieutenant Governor, Speaker, and Governor not be on the same page as much as they were this session. I think that caused a lot of friction and acrimony. I try to tell my friends and family when regular session's over and start reconnecting with some of those folks, they're, how was session? And I think the fact that this happened, and I know many of y'all know it, but I think the final day of session when one state representative threatened to put a bullet in the head of another state representative, I think that kind of summed up. It was a pretty hard session. So I was sitting in the gallery and happened to be watching that, and I said, yeah, that sums things up pretty well right there. And another thing a stat that shows you how hard the session was, I think there was the second most number of bills filed ever in legislative history, over 6,600 bills, but only about 1,200 bills passed. So the bill passage rate was at 18%, which was one of the lowest. It's the lowest bill passage rate I think I've seen in my career. And so that it shows you how difficult it was to get a bill passed this session.
And there were the most number of vetoes as well, were there not?
I think second. I know our previous governor, Governor Perry, I think his first go around, he vetoed 80 something. and then Governor Abbott vetoed 50 this time, and unfortunately, for those in the water world, there was numerous water bills, and we'll talk about those later, that were vetoed. Another thing, the final comment I wanted to make was that, the scrutiny, the intent, there was a very intense scrutiny review of local governmental entities. Saw that throughout the process. Cities, counties, groundwater districts, you name the entity, and there was close scrutiny and a lot of legislation aimed at transparency and activities of local governmental entities. And then, it was very much a focal point of the property tax reform legislation that was filed during the regular session, filed during the special session, did not pass either time, which means we'll get to see it in another special session or in 2019 in the regular session. So that issue is not going away.
Perfect, thank you. And I'm going to turn to Hope and to Brian, especially as co-chairs of the Groundwater Committee. How would you evaluate the role of consensus groups working through this interim? And was there anything different in that process or how TWCA's bills were received? I'm sorry about that.
No problem. I'll kick it off. I'm sure Brian will have some comments. I do believe that the consensus processes are very helpful overall. They really provide a means for the stakeholders to come together, like through the TWCA process. And of course, TAG participated quite a bit, and very grateful to all the members that worked with us in that process. Gives us the chance during the interim to come together in a measured way to work through a lot of the issues. Interim reports and interim charges give a very broad brush and give us an idea of what it is the members want us to look at and what direction they're going in. But it's so much easier, it's not easy, but to come together in that time period where we have time to hash out the issues rather than to try to do it during the craziness of the session. And we talked about, in particular, this session was a very difficult one, a lot of issues going on. So, and even if you can't get to consensus, sometimes it is a really good way to hash out what you can, have the sticking points ready and available in the session, and the members get a really good sense of what the issues are because they attend a lot of these. So a very valuable process. This session, we had a number of consensus bills, more than we've had in the past. We had fewer of them pass than we did in the previous session, but we also had a lot of, as Ty alluded to, a lot of other big picture issues that were on the legislators' minds and differences between the House and the Senate that some of that got caught up in as well. So I think it's a very valuable process overall.
Thanks.
Yeah, I'd agree with that. If you just look historically at just over the last couple of decades at water policy and legislation, it always works out better for everybody if we get together multiple interest groups and stakeholders and try to work together. You had that to a large extent in Senate Bill 1. We did it again in 2000 in preparation for Senate Bill 2, Senate Bill 3, House Bill 3 and 4. You saw it as well. Those efforts pay off. We went through a period of years prior to getting the TWCA groundwater group together where it was just a free-for-all at the Capitol. And if you were part of that, it's like playing alternating Russian roulette. It may work out where the bullet doesn't hit you when you had it aimed at your temple, and you might get what you have passed, and it may not. The way it did work out for about 8 years there was everything died. Almost good ideas died, bad ideas died, because it's really hard to contemplate in whatever myopic view you might have in your part of the world. Here's a great bill that's going to solve our needs, and who could possibly be against this? Well, just file it at the legislature, and you'll find out who's going to be against it. Things you didn't think of in other parts of the state. And so it's not without its wrinkles. We had, some legislators upset that there were some folks working against bills that had passed the 90% consensus test, but it's much better than the alternative, and it's something that the dialogue needs to keep happening in preparation for future sessions.
Thank you. Greg, could I ask you to attempt to classify the types of groundwater bills that we saw filed this session? Of course, a great number of them were consensus bills and dealt with very specific scopes, but would you talk a little bit about the classification of those bills, and perhaps any thoughts on how that impacts Chapter 36 and its discussion overall.
Well, my primary takeaway from this session is that the legislators are very concerned about private property rights and groundwater, and also concerned about the process of issuing permits. As the session progressed, there were debates over whether utilities would be granted permits based on their service area rather than their property ownership, whether district boundaries should be the same as aquifer boundaries, or maybe private property boundaries, whether districts should rely or simplify their permitting process, and whether the current planning process is working, and whether the appeal process should be changed. I hope the takeaway from this session is just how complicated it is to balance the property rights of the applicants and other well owners and other landowners, while still also trying to address things like spring flow and subsidence. While this was one of the sessions that had the most bills ever filed, interestingly, in a non-water session, we also had the most groundwater bills ever filed. In a lot of cases, they were conflicting. As I pointed out, we had bills that were filed saying that we needed to change the boundaries of the districts to more closely match the aquifers, but a bill that made it through the House, made it through the Senate committee, and was never voted on the Senate floor was one that would have required districts to change their boundaries to match a private property owner's boundaries, so that that private property owner would only have to be in one district. So there were some confusing and conflicting things that happened. I think the biggest takeaway from this session is the need to have a much better communication and involvement with legislative staff and committee staff during the interim, so that we can avoid a lot of the problems. As Brian just mentioned, the consensus process is one way to go about doing that, and getting the staffs more involved in that process, I think, would be very helpful. But it is a balancing act in the end, and I think that, my personal opinion obviously is that the locally managed districts are the best way to meet that balance, but be aware that the legislature is watching, and where the districts fail, then the legislature is going to take action to get us to fix that problem.
Thank you. So with that, what I'd like to do is transition us over into talking about what bills passed, what didn't, what got vetoed, and a little bit about how that affects the districts. And before we do, just kind of a reminder to folks who aren't familiar with the committee appointments. We had Chairman Perry, obviously, here from the Senate Committee on Ag, Water, and Rural Affairs. And then we had on the House Natural Resource side, new leadership with Chairman Larson having been appointed at the beginning of the session. So we're going to move on to what passed and what didn't pass. And here you have a summary of those groundwater bills that passed. And so I'd like to start with Hope. Would you mind talking to us a little bit about Senate Bill 864 and what that meant for us?
So Senate Bill 864 was authored by Chairman Perry and sponsored in the House by Chairman King, Tracy King. It was actually a product of a joint recommendation by both the Groundwater Committee and the Surface Water Committee of TWCA. There's a similar consensus effort on surface water. And it provides that TCEQ notices and the approved water right identify proposed alternate sources besides state water, and require that a notice be sent to a groundwater district if that proposed alternate source involves groundwater from within the district. And as I understand this issue, and many of you are probably more familiar with this interaction than I am, is that when an impoundment is no longer, say, exempt for domestic or livestock purposes, and the owner has to get a permit from the commission, if the water is over appropriated in that area, surface water, then often groundwater is looked to as the source to fill that impoundment. But oftentimes the owner doesn't know that they need to get a permit from the commission, from the groundwater district, even though they would get that approval from the commission, and the groundwater district as well doesn't know that that issue is occurring. So this notice would provide transparency up front for the district, the owner, the commission to be aware, and hopefully avoid problems at the end with some type of enforcement or something like that. The bill goes into effect on September 1st, so coming up here. The commission is undergoing a rulemaking on numerous bills from the session, one of which is this one, and I believe they've put out a notice you've probably seen of a stakeholder meeting coming up. I think it's September 11th at the commission to take stakeholder input on rules relating to different bills, including this one, just for those that are interested.
Thank you very much. Brian, I'm going to turn to you now, and I actually have got two bills that I'm assigning to you to talk about. If you talk to us about Senate Bill 865 and 2215, tell us a little bit about what they do, when they're going to come into effect, and what groundwater districts need to do to prepare for it.
Okay, these were both part of our consensus process with the TWCA Groundwater Committee. The first one, House Bill 865, which Senator Perry authored in the Senate and Dwayne Burns carried in the House, was a bill that made legal much of the activities of the group in this room that were previously illegal. And that has to do with electronic banking. Prior to the passage of this legislation, really the only electronic banking type activity a district could do was federal wire transfers. All of your direct deposits and online banking activities were heretofore illegal, but now you're okay. This is one of the few bills that I don't think we ever saw any pushback on. We just hadn't updated the statute since Al Gore invented the internet, I guess, and so we decided to finally get around to that, so you can all go about your direct deposits and online banking now. House Bill 2215 by Representative Price and Senator Boris Miles was kind of a joint effort from the TWCA group to synchronize the deadlines for the adoption of DFCs and how they plug into the regional water planning process. It was also an effort, the Water Development Board, as part of the state water planning process, submits recommendations to the legislature for change, and they had submitted one on this as well. And so as we got to the Capitol and the session was starting, we figured out we had this effort going. Price, I guess, because of his service on the Sunset Commission, had picked up this recommendation from the Water Development Board and filed a bill. And anyway, we dovetailed our efforts, coordinated with the Water Development Board to work out language that was good with this group and with them. And got that updated. And the ultimate bill, as it passed, established a new deadline for the next 5-year cycle of DFCs. Proposed DFCs have to be adopted by May 21st of 2021, and then the final DFCs have to be adopted by the GMAs by January the 5th of 2022. And evidently, in the mysterious process of dovetailing DFCs, regional planning, and state planning, that's all going to finally dovetail nicely to have those numbers ready for the regional water planning groups, according to the Water Development Board. We also clarified an issue, a legal issue that's come up in this last 5-year cycle on when the individual groundwater districts adopt the DFCs after the GMA adopts the final DFCs. I think it was as soon as practicable, or after they adopt them, you were supposed to adopt them. But we had this Water Development Board rule that says we were supposed to wait till they declared your DFC resolution and explanatory report administratively complete before you adopt them at the local level, the ones that apply. That's in the law now. Now we wait for the Water Development Board to declare them administratively complete, then the individual groundwater districts adopt them. We also cleaned up some of the language in the individual groundwater district public hearing process. After you have proposed DFCs and you go out for the public comment period and hold hearings, there was some confusing language in the statute that seemed like you cut that off short, like you were supposed to get back together as a GMA before the public comment period had potentially even closed. We got all that straightened up, and we got that all passed and in the law now.
Thank you. Greg, if I could turn to you to speak to Senate Bill 1009.
I'll be happy to. I think Senator Perry kind of covered this a little bit, so I'll keep this real short. 1009, which takes effect on September 1, requires all GCDs to list all the requirements for an application to be administratively complete within its district's rules. Most rules include a catch-all statement that the GM or the board may request additional information if necessary. That's going to have to come to a stop because we're not allowed to do that anymore. There are reports that that provision was being abused, that multiple requests for more and more information was being made to put off consideration of an application. And so the law now requires that all of the requirements that you have for an application or what it takes to be administratively complete have to be listed within the district's rules. Now, I personally recommend that you add a provision that says either classifies which types of permits need to have which kinds of rules, or has a statement that says the GM may waive those requirements for certain permits in order to make each application most efficient for that type of applicant. For example, and if there's an application for an agricultural irrigation, that may request information about the type of crop to be grown, the irrigation methodology to be used, and the total acres to be planted, whereas an industrial application, you don't need any of that information, so it'd be silly to ask for it or require it to be filled out. The districts must also be careful to only request information needed to assess whether the groundwater would be put to beneficial use without waste, not unreasonably affect existing groundwater and surface water resources or existing permit holders, and those other requirements that are listed in 36113D. The law specifically says you can only ask for information relative to those considerations needed to consider and grant the permit.
Thank you, Greg. I appreciate that. And finally, Ty, if you could speak to the last bill that TAG had, at least on his tracking report, Senate Bill 1511. Tell us a little bit about what that does.
Right. Senate Bill 1511, filed by Chairman Perry, and Representative Ford Price was the House sponsor. Basically, it was another step in the state and regional planning process. You know, we've, from day one of the Senate Bill 1, when Senate Bill 1 passed and the state and regional planning processes were created, it's always been an evolving process. We've learned as we've gone on, just like the GMA process. And so this was an effort to try to keep updating the state water and state water plan and the regional water plan, created more transparency, and it required, now that we have SWIFT funding and regional water planning groups determining what projects are priority projects, what kind of progress are these regional water planning groups making and the local entities making in implementing the state water plan, the regional water plan that they've been working on. So there's progress reports, there's more transparency, and actually a feature that I really liked was it talked about a simplified planning process that once every other 5-year planning cycle at the regional water planning group level, you can follow a simplified planning process so that you wouldn't have to go through the full bore when you have a lot of factors. Your water needs haven't really significantly changed, your demands, your water supplies. You have to do a few updates on your modeling and some science information, but other than that, there's a streamlining process, and I've really heard that a lot from the regional water planning groups that, we're going through the motions because we just really things haven't changed in the last 5 years for us. So this is a step towards allowing that process to be streamlined to help not waste resources that are so valuable these days.
Thank you. So perhaps more important than what passed is a discussion about things that didn't pass and those things that got vetoed. And so, panelists, we have 15 minutes to get through all of the bills that were vetoed and that didn't pass. So we're going to have to speak to them broadly, quickly. Correct. So I'd like to start with those that got vetoed. And Brian, perhaps you could start with House Bill 2377.
Okay. House Bill 2377 was really part 2 of a few sessions of brackish groundwater production discussions. Last session, 2015, Representative Larson passed House Bill 30, which set up the process for the designation of brackish groundwater production zones by the Water Development Board. What we were unable to get consensus on that session was what are the rules of pumping brackish groundwater out of one of those designated zones, and House Bill 2377 tried to accomplish that. It was a process where a landowner could petition for rulemaking at a groundwater district. They had to set up a rulemaking scheme that involved 30-year permit terms. A groundwater district, if they thought that the pumping as it occurred over the period was causing more significant declines than were anticipated or otherwise had negative effects, they could go to the Water Development Board and ask for a report and evaluation on that, and if the Water Development Board report allowed them to scale that down, they could. Ultimately, this thing got vetoed, and it didn't get vetoed because of the merits of the bill. It got vetoed because of a not very well hidden confrontation that exists between Representative Larson and the governor, and We had a couple of our other TWCA consensus bills that were stuck on as amendments on the Senate floor. Wisely, in retrospect, we pulled those off because we smelled the veto coming and it got vetoed, but we'll be back at the grindstone next session to figure out what the pumping rules are going to be for these brackish groundwater production zones.
Thanks. And what was great about 2377 as well is that it was the result of a very well-coordinated stakeholder process, which Shannon should definitely be commended for coordinating, but that was very nice to see such a diverse group of stakeholders coming in and working on that bill.
Yeah, Chairman Larson had a number of stakeholder meetings on that thing, oil and gas interests, municipal interests, landowner interests, groundwater districts. We'd hammered it out, but ultimately it died with the stroke of a pen.
Thank you. Hope, would you speak to us about House Bill 2378?
So House Bill 2378, which was also vetoed, was by Chairman Larson and sponsored in the Senate by Chairman Perry. It would have automatically extended an expiring export permit to conform to the remaining term of the related operating permit. And then those two permits would roll forward together for whatever term that operating permit was renewed or remained in effect under Chapter 36 renewal provisions. So they would align and then roll forward together was the concept. And the idea was really to mirror the same effort that was made in the previous session with respect to operating permits and the renewal process for that. Really, it was designed to reduce uncertainty for both the permit holder with that conflicting permit terms, as well as the districts on how to deal with that and provide guidance. It was a TWCA consensus bill, so many TWCA and TAG members worked quite a bit on that language as the operating language in the previous session. So, you know, it's certainly, again, as we talked about brackish, it'll be something that I think there's a lot of stakeholder interest in continuing to discuss, and we'll keep working on that.
Great, thank you so much. Greg, Representative King's House Bill 3025, tell us about that. You were very involved.
Unlike these other bills you're hearing about, this was not vetoed, as far as I know, for any political reason or personality conflict, but just because the governor didn't like the bill. The current law allows a groundwater conservation district to go on private property and permanently close any open or uncovered well, as long as they give the property owner 10 days notice of their intent to do so, and then put a lien on the property for the cost of having done so. The language in Chapter 36 doesn't match the language in Chapter 1901 of the Occupations Code, the Water Well Drillers Act, where it talks about plugging abandoned or deteriorated wells. The bill would have made the terminology and some of the deadlines the same between those two chapters, and would actually have limited the authority of groundwater conservation districts to only plug deteriorated wells, meaning those that are currently causing pollution, either to groundwater resources or to surface water sources. So the bill was cutting back on GCD authority and making the terminology between the two chapters the same, but it was vetoed because it gave districts too much authority. I think what the governor is saying to us is that it didn't go far enough in limiting GCD authority, and therefore he wanted to see some bill come back later on. I don't think this bill is going to come back, but we'll have to see in the future if we can work out something with the governor's office on what he wants the law to say.
And of course, this was an important bill in terms of addressing the issues of water quality and ensuring that there are adequate means to protecting that.
We have a number of older, deteriorated wells that need to be addressed, and private property owners are having a tough time, even with the cost of taking care of it themselves. We also have a number of other newer wells that were not necessarily completed properly. We got problems in Bandera County, Central Texas, in the Carrizo Wilcox, and even out in far west Texas. So the problem is kind of statewide, and it would be nice to find some methodology to address it.
Thank you. And finally, Ty, the list of bills that were vetoed, will you tell us a little bit about Senate Bill 1525?
Yes, Senate Bill 1525, again, Chairman Perry bill and also Chairman Larson. And it was a Water Development Board study bill for the Water Development Board to conduct a study to look at water needs, water availability for, looking at aquifer storage and recovery projects, brackish groundwater, marine seawater desalination, and public-private partnerships, just really trying to have a focused study from the Water Development Board on what the state can do to help meet its needs. And so it was vetoed. The comment from the governor was, oh, the Water Development Board can do this study anyway. Editorial comment, Water Development Board, like many state agencies, they're strapped for resources. They're trying to keep, all their balls in the air, trying to take everything they can. Legislative direction goes a long way towards making something like a study like this occur. But I think, like Brian alluded to earlier, this was part of a conflict, is I guess a good word, between Chairman Larson and Governor Abbott.
Thank you. And of course, it's important to talk about those bills that were vetoed because they were bills that passed that otherwise had gained favor among stakeholders and legislators. So interesting to bring those up as policy discussions moving forward.
Sarah, I'm sorry, real quick comment about 2377 and 2378. I think a lot of those provisions can be implemented by rule by the districts. We want to make sure we don't do something that's going to be necessarily in conflict with what the governor wants. But I think we can go a long way, especially on extending permit terms and things like that. Districts can fix that in their rules. They don't need a statute to move forward.
Thank you. That's a very good point. And I'm aware also that there are some districts that are already looking at the brackish water production rules as well and trying to be proactive in moving forward with that. So with that, I'd like to take us to the list that didn't pass, and it's 2 slides. It's quite extensive, so we're going to have to move through them quickly. And what we've done is we've allocated a handful of bills to each of our experts up here. Ty, I'm going to start with you again. We did speak a little bit about Senate Bill 1392 earlier today, but if you would talk to Senate Bill 1392, House Bill 1318, and House Bill 3417.
I will. Okay. So Senate Bill 1392, Chairman Perry's omnibus groundwater bill that he talked about, mission accomplished, Chairman Perry. He definitely generated discussion, significant amount of discussion this session. I mean, it was a 40-something page bill. It went everything from, it spanned the globe, from reasonable office hours, when an office hours of a groundwater district would be open, to what export fees a district would collect, what they could be spent on. So it really had the gambit, and during the process, during one of the committee substitutes, some language was put in that would restrict the use of historic use, a permitting structure, management structure by groundwater districts, and that generated even more discussion about this bill and was a subject of a lot of committee hearing one Monday night that I think a lot of people in this room attended. So definitely look forward to working with Chairman Perry and Chairman Larson and continuing to talk about the concepts that were brought up by this, by Senate Bill 1392. One of the main ones that I took away from the process is this, what Chairman Perry talked about earlier, trying to figure out where districts working together, figuring out where their rules can be similar. If they are different, why are they different? Really laying out for scientific and groundwater management reasons, why are the decisions made by districts to go one direction or another, as opposed to purely political decisions. So, that's a work in progress, and that's something we'll spend a lot of time on the interim and next session on. So I know that's something to look forward to. And then House Bill 1318 by Representative Lucio, that was a refile of a bill from a previous session. That was aimed at requiring groundwater districts to consider if they regulate on acreage or tract size, the production of groundwater, they would consider a retail public utilities. We're talking cities, water supply corporations, investor-owned utilities. They would, the groundwater district, when considering these factors and making permitting decisions, would look at the acreage owned or leased by a retail public utility. And so I think one of the fears here, and I'll move on to the next bill quickly, I know, but one of the concerns that retail public utilities have in the districts that use a correlative rights type approach is that they don't have enough money to go out and rope up the amount of land that's needed for the production that they need. So I think that'll continue to be an issue. I think that's something we'll be working on during the interim, because it'll be back probably for a third time this next session, and I think it would be good if we had some kind of consensus on what direction that bill needs to head. And then House Bill 3417 by Representative King. This was a bill, I think if other people on the panel up here can correct me, but I think it really came to light during the whole Hays County situation in 2015. And so electric purification and with several districts in Hayes County, but it's basically when it would add language, it would have added language to Chapter 36 that when a district is considering, they're looking at all the wells that a proposed well would have an impact on, that not only would they consider, existing groundwater resources, existing surface water resources, existing permit holders, it would add to that list, wells that are, exempt from permitting requirements. So that, and that we're talking domestic and livestock type wells. So that was something that, didn't pass, but I think that issue will be on the list of issues we'll keep working on.
Thank you. Greg, could I turn to you to speak to Senate Bill 862, House Bill 4122, and Senate Bill 189?
She asked that like I could say no. I don't think I could say no. Senate Bill 862 is the bill that you just heard about from Senator Perry. It had to do with attorney's fees. Senator Perry expressed a philosophical objection to the provision we have now, which allows a groundwater conservation district to recover its attorney's fees, court costs, and expert witness costs in any case in which the district prevails. It's a one-sided provision. There's no similar provision for the other litigants to win their attorney's fees should they prevail, and Senator Perry has an objection to that. Now, that provision was added in 1995 after a failed attempt to get the Attorney General to represent groundwater conservation districts as regulatory agencies in the state charged with protecting groundwater. The districts felt like they should be represented by the state's attorney. But the fiscal note associated with that request would have killed the bill. So we went with this provision instead, and I assume that this is going to come back. House Bill 4122 dealt with the transfer of large properties from one district to another, where he had a large piece of property, and at one point it was at 5,000 acres, another point 1,000 acres. Somebody suggested 100 acres. You could petition districts to move all of your property from one district into another and have it all covered by one district. Now, of course, that flies in the face of the other considerations that we talked about during the session, that the district boundaries should follow aquifer boundaries. And, of course, that doesn't even talk about the situation where you might have one district that regulates, like the Edwards Aquifer Authority, that only regulates the Edwards Aquifer, and that overlapping with other districts that regulate other aquifers vertically, and that same landowner having to answer to two different districts depending on which aquifer his well is bottomed in. So it was a complicated issue. The House amendments that were added to the bill eventually killed it in the Senate, but it did make it all the way through the House and through the Senate committee before it died. Finally, Senate Bill 189 had to do with the notice and applicability of injection well applications. This one was filed and never heard, so I'm not sure if this is going to come back or not. This has to do with an ongoing problem of, well, there's two real problems here. One is whether or not groundwater conservation districts have standing to object to injection well permits and file protests and actually contest injection well permits before the Railroad Commission or TCEQ. And the second problem is that the TCEQ currently regulates injections for aquifer storage and recovery the same way they do injections for waste. And the bill would have tried to address that and make many of the provisions dealing with the waste injection permits not applicable to an ASR project. Again, because the bill didn't receive a hearing, didn't move at all, I have no idea if this is going to come back or not.
Thank you. I'm going to move on to Brian to speak to us a little bit about House Bill 180, House Bill 3166, and House Bill 3028.
Sure, these are all bills that made it through the House, did not make it all the way through the Senate before end of session. House Bill 180 was our state auditor bill, second session in a row that it got through the House and didn't quite get through the Senate. Would have got the state auditor out of the business of reviewing districts' achievement of their goals and objectives in their management plan. The thought behind this being, since that provision was added in Senate Bill 1, we have this big TCEQ process now that can review your achievement of DFCs and the implementation and enforcement of your rules, and that it's no longer needed, and that the state auditor's office requirement just kind of serves as a disincentive for proper utilization of management plans in groundwater districts. I think we'll try it again probably next session. House Bill 3166, Eddie Lucio III carried both of these bills for us. This was another TWCA consensus bill that would have added an additional consideration in the DFC process, which is a concept called modeled sustainable groundwater. which would be a number calculated by the Water Development Board on what the amount of water that could be pumped sustainably in an aquifer could be. Another piece of science in a session that we heard a lot of rhetoric about wanting groundwater districts to use science. This would be kind of another bookend on the other end of TERS, which is a huge number on how much water is available. This is how much you could pump in perpetuity. It died. We had some concern raised from some folks in the Ogallala area that they didn't like the bill because they didn't want an implication that the Ogallala could be pumped sustainably, and what could that mean to pumping in the Ogallala. So we had a bracket put on in the House that carved out the Ogallala, and thought it might move forward through the entire process, but it didn't. It stalled out in the Senate. And finally, House Bill 3028, which was not one of our bills, by Representative Dwayne Burns of Cleburne. This was a Farm Bureau bill, and it's a bill that it was big and bold. It went forward with trying to define what fair share under the common law is by requiring districts to quantify the amount of groundwater in place under every single tract of land in the state, and somehow do some correlative rights system to limit pumping to that quantified amount, and to not allow uncompensated drainage, confiscation by a neighboring landowner. I think it's a well-intentioned bill and keeping with the themes of protecting private property rights. I don't think I've ever seen any piece of legislation that had private property rights mentioned so many times in one piece of legislation. But it also showed a little bit of confusion on some of the opinions of the Supreme Court in the Day case and others on exactly what a fair share is, and it never got out of the House committee, but I think we'll continue to see these themes moving forward.
Thank you. And finally, Hope, if we could end with a discussion on House Bill 31, House Bill 3043, and Senate Bill 1053. Appreciate it.
Sure. So House Bill 31 by Chairman Larson, and was sponsored at the Senate by Senator Perry, Chairman Perry. The bill was an omnibus bill dealing with several different regulatory matters in Chapter 36, but really it can be broken down into about 5 components. The administrative completeness bill that ultimately passed, Senate Bill 1009, we already talked about. It also included a provision that would require a district's decision to grant or deny a permit, an application for a permit or permit amendment, to be governed by the rules in effect at the time that the application was submitted. This was really mirroring a provision in the local government code, vesting provision in Chapter 245, bringing that to the groundwater districts. It also included direction to groundwater districts in connection with the adoption of a moratorium on issuing permits. It included specific timeframes and procedural requirements for notice and hearing, that sort of thing. It eliminated the separate export permit going forward prospectively, but it did grandfather existing export permits and apply the language we talked about before on the automatic renewal to those grandfathered permits. So that's how it dealt with that particular issue. And the impetus behind 31, I believe, and as the chairman has talked about, was an effort to provide for a more predictable and more timely process for GCD permitting, address some of the concerns with transport permits. The bill did get through the House, did not make it through completely through the process in the Senate side. But I think these are issues we'll continue to see resurface. Chairman Larson did refile that in the special session, and we had a hearing where we discussed that more. So I think we'll be entertaining those concepts again.
Thank you.
And then House Bill 3043 was authored by Representative Paul Workman, companion Senate Bill 1528 by Senator Creighton. And this was a TWC, a consensus effort bill. It would have added permissive authority for GMAs to add voting or non-voting members to the GMA. And it also required the chair of each regional planning group located in the GMA and the GMA itself to appoint members to a joint planning advisory committee, basically to make recommendations regarding the DFC to the GMA. And the members of the advisory group would mirror the interest groups represented in the regional water planning statute, municipalities, industrial, environmental, and that sort of thing. And really this was designed to address the concern regarding the DFC process that's been expressed by stakeholders of kind of moving beyond the public comment for additional stakeholders, increased participation by non-GCD interest in the process, kind of better coordinate the GMA and regional water planning process. It was a very extensive discussion, and this was kind of the approach the committee arrived at, sort of a middle ground. Couldn't quite get over the finish line, I think, on this bill, and we still had, with some of the stakeholders as well. But it was a really hard negotiated sort of middle ground for the committee. We spent, I think, the most time, Brian, if you would agree, on this issue in the committee. So again, I think we'll see continued work on this concept because I think that increased participation is an issue that continues to be discussed. Last bill is Senate Bill 1053 by Chairman Perry. This would have substantially altered the process for appealing adoption of DFCs by districts. The bill would have eliminated the current role of SOA in that process and provided for a direct appeal of the DFC to the district court, essentially. My understanding is this was an effort to streamline that process of DFC appeal and perhaps minimize cost or time that would be associated with going through SOA if ultimately you were going to end up in the district court. But there were concerns expressed with respect to having that SOA process in place that would provide for the development of a record and then combine that with a limited standard of review in court, or do you go straight to court and have the de novo standard of a full review there? But the biggest concern, I think, that was expressed by a lot of folks, including districts, was that there needed to be more time with the current process. And House Bill 200, which adopted the SOA process, was just in the previous session. And so getting through a round and really looking at what appeals came out and how it worked through that process would be important before moving forward with any changes. Chairman Perry agreed to that and ultimately said, let's pin this for a couple of years and continue to talk about it. So ultimately, that was where it stopped in committee.
Perfect, thank you. So we have just a minute or two left in this, and I know that it's like drinking out of a fire hose. There's so much there, but I think what's really important to take away is, first of all, what passed and what it is that you're going to need to be looking for within your individual districts to make sure that you're up to date with your rules, but also looking at some of the themes that emerged in those bills that were vetoed and those bills that didn't pass, because as we've heard through our various speakers and panels, those are ongoing discussions about permitting structures and permit timing and the administration and similar rules and all these things. So I'd like to ask each of the panelists to comment on which topics you think are most prominent coming out of session, going into the interim, that we should focus on, and what would you recommend that districts do in engaging those subjects? Ty, yeah, sure. Please.
I think Chairman Perry said the attorney fees issue we'll be working on that during the interim. I think the similar rules concept, trying to make sure districts are working with one another and explaining why their rules are different or similar. I think that's a big part of the equation. Retail public utility, this House Bill 1318, I think that's something that we'll be working on. One of the things that I found ironic during the Senate Bill 1392 process is references were made to a definition in Chapter 36 that's been there for a long time, and I honestly just really haven't paid as much attention to it as I have of other provisions, but it talks about subdivision of a groundwater reservoir. And that's something that the more I talk to people about it, the more like, well, yeah, I don't really know what that means. And so I've talked to hydrogeologists, I've talked to, groundwater folks, attorneys, you name the people that are involved, and people are like, I really don't know exactly what that means. So I think that might be something we'll work on to clarify when we're going through some kind of similar rules process, to define what kind of area we're looking at when we're talking about similar rules, and maybe clarifying that definition of definition that's been there for years and years.
Thank you, Ty. Hope, what are your thoughts on it?
I think that echoing a lot of what Ty just said, but also when we talk about the issues of consistency or similarity, uniformity, I do really feel like we talk about there's a lot of limits to what you can do with that because of all the differences in the districts and the geology and the uses. But with respect to brackish, I'd love to keep that momentum going because I think that's sort of a whole different spectrum of these zones that we've talked about. But it's really an area where I feel like a lot of the stakeholders, and we talked about the stakeholder process, have agreed that that is an area where we can have some uniformity in how we proceed with those rules and that were acceptable to everybody to work within those zones. And I'd love to keep that momentum going, like we've talked about, and pursue that at a district level and another legislative level, but just to keep it on the radar for sure. The efficiency and predictability themes that we talked about, from the municipal perspective particularly, those are important themes that we'd like to continue. I think the concepts in 31, the export extension bill, are all things we'd like to continue to keep on the table. I think the DFC process, the availability will remain. We've heard a lot of that discussed from the chairman. I think what we can do, I'd love to see us continue to work. We already talked about the consensus processes that we have going. Those are very valuable, and I think we can continue to work on a lot of these things through that process.
Okay, thank you.
Without repeating what you've already heard, I think the GMA educational process to put together those lists of differences in their statutes, their plans, and their rules, I think is extremely important. But I want to address the natural tension that we're going to continue to have between the need for planning and the need for permitting and the need to have some teeth in the planning while not at the same time creating this necessity that you have to go get the plan challenged in court before you can get the permit that you want. I think planning is absolutely necessary, but shouldn't be done in a way that requires litigation at the end of it. At the same time, if there's no teeth in the plan, it doesn't really mean much. There's not much of a plan. I find it really interesting that we have these continuing fights over the planning process for GCDs and GMAs, and yet the regional water planning process, which has some real teeth to it in that you cannot get state funding for any project that's not included in the regional plan, there is no means to appeal. The best that you could possibly do, I think, is if once the state water plan is adopted by the TWDB, you might be able to file an appeal challenging the state water plan. I'm not sure on what grounds you would file that appeal. I think we need to get away from challenging the plans, and we need to come back to challenging just the individual permits. And finally, I want to mention to the districts here, you have got to do a better job educating your members, the legislature, and your public about what it is that you do, how you do it, and why it is that you do it that way. If the public isn't there supporting you in the decisions that you've made, then it's just the few applicants there fighting against the districts. And the districts eventually will lose that fight. This has got to be put forth as the people who support the decisions and support the rules you have versus the people who don't. And that way the district is simply doing what the people want them to do, and that's a better fight before the legislature than the one we have right now, where it appears it's districts versus the permittees. That's not a good fight, not a good way to present this to the legislature.
Thank you, Greg.
Greg stole my thunder there. I think the education of legislators and your landowners, permit holders is the key. I mean, I agree districts need to do some of this work, but the prevailing thought I took out of the last legislative session is there are a lot of well-intentioned ideas that don't play out in reality. I think the legislature envisions aquifers or subdivisions of reservoirs as one big bathtub where everything behaves the same no matter where you are over it. There's no appreciation for the fact that the Trinity outcrop in the hill country, the best you can hope for is a 5-gallon per minute household well so you don't have to truck water into your house during the drought. And in the exact same subdivision of that reservoir, 2 counties to the east, wells are 2,000 feet deep. Only public water suppliers use them. It's a different set of circumstances. It's the same aquifer. There's legitimate reasons why we have local control and different land uses, why we regulate the city of Houston and Harris County differently than we do the rice farmers, because the regulations wouldn't make sense. We tried to deliver that message in the face of legislation that would have unraveled our current structure of regulating groundwater, but it doesn't really it's not really received that well just coming from groundwater districts and their lawyers at the Capitol. When you have a permit holder, you know, like it or not, over a half century, we've had this type of regulations. We've had permits issued. We've had, you know, farmers, cities that have relied on that, made investments in the permits received. It's getting those folks to the Capitol to say, look, we can't do it all the same way everywhere in the state. And what you're proposing would unravel everything we've got going. To hear from those folks, the landowner, the rice farmer, the city, the small city that can't afford to fix potholes and it's being told it needs to come up with enough money to, you know, go buy 20,000 acres of land in the Metroplex to continue justifying its pumping to its customers. It's those types of things and having those folks educated and talking to legislators that are going to make the difference going forward. And it's incumbent upon this group right here to spread that word and to try to work with legislators in the interim to educate them on those issues.
Thank you, Brian. Unfortunately, we are out of time. I've actually stolen a few minutes from your lunch. But I did want to mention that if you're interested in reading a little fuller review on some of those bills that did or did not pass, TAG does have a legislative wrap-up available on its website that you're welcome to go to. I wanted to make a quick announcement about lunch before I lose your attention. You're going to exit these doors and turn to the right, and lunch will be served there. We have a wonderful barbecue lunch for you and a lunch keynote as well, so I encourage you to move in that direction. And before we close, I want to thank each and every one of you for your time today, but also for your very hard work through session. I know there were a lot of sleepless nights, and so we really appreciate your work. Thank you so much.